By the time the deposition rolls around, the process of discovering facts in the matter has largely come to its final phase. By this point, you have probably seen much of the relevant information that has come to light. You have certainly seen the information that relates directly to the opinions you formulated. You have no doubt contributed your own research and investigation to the discovery process in order to complete your expert report. You should come to your own deposition well-dressed and well-rested. You should be well-dressed because attorneys come to depositions well-dressed. You will be more respected and better treated during the deposition if you look the part. You should also be well-rested because it is overall a fatiguing process, physically, mentally, and emotionally. It can go on for hours and sometimes days. From the perspective of physicality, you may not be used to sitting for so many hours at one time. You may develop aches and pains. You may already have physical injuries that will become distracting to you after several hours of sitting in a chair. From the mental perspective, you have to think constantly during a deposition, not only about the right answers to the opposing attorney's questions, but of the best way to phrase those answers. Beyond that, you will be a better expert witness if you also analyze the intent of each question. It will help if you can think ahead to see where each question or line of questioning seems to be leading. Anticipation will enable you to construct better answers and to prepare better for follow-on questions. From the perspective of your emotions, you know that the opposing attorney is seeking to discredit your positions and to undermine your confidence. Let's take a look at some of the effects of your testimony. The deposition phase of the case usually represents the final stage of discovery. At this point, the discovery concerns more than just the facts in evidence. Behind this factual discovery is the discovery of information about you as a witness in a trial, if one is to occur. The question of how effective a witness you will be at trial lies beyond these simple facts and beyond the opinions you formulated and beyond even all the organized bases for your opinions. I have been an expert in more than 100 cases over the years. Most of them settle or end as a result of what is learned during the discovery phase. There's no hard number, but in my experience, no more than 20% of all the cases actually get to the deposition phase, and less than 10% in total actually get to a trial. Litigation is expensive, and hiring experts like you and me makes it even more expensive. If both sides are reasonable and can settle, they invariably will do so. However, you are a major reason why two sides decide to settle. If your work is solid, and if you look and sound solid, you will impress the attorneys as a witness who will be believable and convincing to a jury. Regardless of which side hires you, you can directly affect whether the attorneys decide to go to trial or settle. You're part of the discovery process itself. What they discover about you can help or hurt one side or the other. You are actually a chip in this metaphorical poker game. A deposition is a legal forum in which you offer sworn testimony. A key tactic is that if the matter comes to trial, and if you are unavailable to testify, the attorneys can use this deposition transcript in your place. They can read anything they like from it during the trial. Naturally, your smiling face and convincing personality and tone of voice would be preferable to someone else intoning the words that you said during the deposition. However, you should realize the import of each of your words when you speak them during the deposition. Even though this lesson focuses on depositions specifically, the remaining 4 lessons on testimony apply to testimony in both depositions and trials. There will be many questions, and you should apply your intelligence and these trainings in the same way, whether in a deposition or in a trial.